This is A New Angle, conversations about how we're doing and where we're going. I'm your host, Justin Angle. This show is supported by the Headwaters Foundation, First Security Bank, and the University of Montana College of Business. Hey folks, welcome back, and thanks for tuning in. It's time once again to check in with A New Angle's chief legal correspondents, Craig Cowie and Constance and Craig, law professors here at the University of Montana. 2026 is sure to bring many consequential legal developments, and Constance and Craig will help us try to make sense of what to expect. Constance, Craig, thanks for joining me.
Thanks, Justin.
Thank you.
Yeah, so about a year ago, we had a conversation in this room about DOGE and USAID and the future of several agencies. Gosh, that seems like ancient history in many ways.
It really does.
Not much going on now. Things are pretty boring in the legal world, aren't they?
Yeah, they've really settled down.
Yeah. Constance, how are you making sense of what to expect in 2026? What's the big question that you are starting the year off asking?
Yeah, I mean, you kind of take things one day at a time, and it depends on what's been in the news most recently. But I think fundamentally, we're seeing a real test on to the structure of powers under the U.S. Constitution. It used to be the case in constitutional law classes that the students were just so excited to talk about individual rights, right?
Yeah.
Right to free speech, equality rights, right to due process, abortion, those kinds of things. And now all of the action is really with the structure of government because of the, as we'll talk about, the unprecedented assertion of vast executive power under the Trump in the second term.
And how does this play out? Is this an issue that's central to the court cases that are being adjudicated, or is this the actions of the various branches of government that we should think about? I mean, the two things are related, but what's a framework for thinking about this question?
Yeah, I think the best way to think about it is that we have this constitutional structure that's designed to have the branches sort of check each other, the three branches being the executive, the legislative, which is Congress, and then the judiciary, which are the courts. And so that if any one of the branches sort of steps out of line, the other branches will check them. I think an often forgotten part of that is that the public at large also plays a role. It's not really sort of directly in the Constitution, but it's an important, like, how people react to what Congress is doing, what the executive is doing, what the judiciary is doing matters.
And do you mean that in terms of voting behavior or just public sentiment?
I mean public sentiment and voting behavior and demonstrations and so forth. And, we've seen historically, like around Watergate or the civil rights movement, where things happening in the public very clearly both impacted how the executive responded, how Congress responded, and how the judiciary responded. I don't think any of the branches are immune or should be thinking of themselves as immune to being part of the body politic as a whole. Okay.
So, Constance, where is the rubber hitting the road right now, as you understand it?
Yeah, I think it depends on where you put your focus.
Okay.
But if you look to the courts, I think we are looking at the executive removal power and the rise of the unitary executive theory.
Okay. Yeah, and that's a term that gets bandied about. That's a term that gets used and you hear it in the media, but what does the unitary theory of the executive mean, and where did it come from? Is it in the Constitution? Where does it live?
It is. The argument is that it is in the Constitution because of the Constitution structure, that the executive branch is the only branch of government that is a single person, and that's by constitutional design. So that's kind of where it derives from. The theory, and you'll see different uses of the theory, and it can be used kind of as a fill-in for any broad assertion of executive power. But for academics, we think of it as instead the theory that the executive is completely in charge of those things that fall squarely within the executive branch. But it doesn't necessarily mean that specific actions fall within the executive branch. And so that everybody who works for the executive is responsible to the president, because the president is the only person who is democratically elected and responsible to the people within the executive branch.
So can we press on this a little bit? So this concept of the independence of the Justice Department, for example, that could potentially fall away under this unitary executive, right? Because the Department of Justice is within the executive branch of the government. So under this theory, the president could direct the Department of Justice to do whatever he or she sees fit.
Exactly. And the Department of Justice is a very good example that kind of puts the theory into action, because there isn't any controversy about whether or not the Department of Justice is an executive agency.
Right.
Its function is exclusively executive. And you see state constitutions, for example, doing something very differently with independently elected attorneys general very often, that really have a structural mechanism to resist this form of unitary executive. But under the federal constitution, that's all falls under the president's control.
So this concept of independence is strictly a norm that we've chosen to adhere to for the last few decades.
Yeah, and I think probably longer than the last few decades. And when I describe the unitary executive theory, I'm not saying that that's the way that the executive branch ought to operate.
Sure.
And I think that there are good arguments that constitutional norms should factor into our constitutional interpretation as well. That's not the view that's gaining steam, though, and that appears to have garnered the support of a majority of the justices on the Supreme Court, is this unitary executive theory.
Okay. So, Craig, how is this being tested? I assume the premise of this question is that the Trump administration is asserting power in a different way than prior administrations, or maybe they're being allowed to get away with asserting power in a certain way.
Yeah, I think it's a combination. So when Constance said that we were sort of in an unprecedented situation, that's exactly the right word. And it's both in scope, so in the quantity of actions that are unprecedented that are happening, and also in the nature of the actions.
Okay.
So, you talked about breaking the norms, but if we look at there have been mass firings, attempts to eliminate congressionally created agencies,
right?
An attempt to eliminate birthright citizenship, a taking of sort of the tariff power to a new level where the president has power to institute tariff, something that's traditionally a congressional power, and there's only a limited grant through statute to the president in some situations. There's the deployment of the National Guard troops, the federalization of them. There are the attacks on the Venezuelan boats, and then also the extraction of President Maduro and his wife, and a bunch of the removal of people from the United States and either being sent to, sort of the horrific prison in El Salvador or South Sudan with no connections. All of these things, and in fact, even I would argue the sort of mass detaining of U.S. citizens, lawful residents, and people here who might be here without authorization, all under the premises of sort of racial profiling, which in the Vasquez-Perdomo case, that's, I think, unprecedented both in scale and scope. I think there have always been allegations of discrimination made against individual officers or even individual departments, but I don't know that we've ever seen anything on the scope of the ICE actions around the country, and also the basis for them. So in Vasquez-Perdomo, which was there was a case, it's the status is that this action was enjoined by lower courts, but the Supreme Court lifted that and said, no, you can keep going. And what had been enjoined was an argument that you can't make mass immigration arrests based on someone's apparent race, where you find them, their job or parent job, so day laborer, who might be at Home Depot or grocery stores, and the language they appear to be speaking. right? Which were, on those four things, an argument was made to the district court that that's not enough. That's not reasonable suspicion, which was the standard. But the Supreme Court reversed that stay. So the case is still going, but the stay has been reversed, which means the conduct can go forward while the court's deciding. And I think that's something that we can dig into later, because it's a really important but somewhat arcane and technical to the layperson development of the way the court is processing these claims.
Okay. Yeah, let's maybe pause on that, and we'll circle back to it if we have time. So in this broad question of assertion of power, separation of power, are there key cases before the Supreme Court this term? Are there cases that they have agreed to hear? And maybe within that answer, inform us on just the timing and cycle of how these things happen before the Supreme Court.
Yeah, so the one thing that is true, and this dovetails with what Craig was saying, is that the timing and cycle is changing to some degree because of the amount of litigation, because of the amount of sort of unprecedented executive action driving a lot of litigation, where we're seeing major cases frequently come up to the Supreme Court on an expedited timeline without oral argument, with very limited briefing. And the court is just asking whether or not to pause preliminary decisions by lower courts. And people refer to that as the shadow docket or the emergency docket, or there's a bunch of words for it. But and so these very barely reasoned decisions that are delivered without the benefit of full briefing and argument are becoming part of the cycle of the Supreme Court's work. Really major decisions are being decided that way. And so that's a new thing, and that happens year round.
And that, I mean, it seems like, as you said, the reasoning that is at least made available to the public is thin in these cases. So is that reflective of how much time and thought is put into these cases? Like, how do we make sense of that as a public?
Right. So, I mean, relative to the merits docket, so the Supreme Court's ordinary business, where you get briefs and you have an oral argument, you can listen to that, you can stream it live, you can listen to it later, and then you have extensive decisions that are, if anything, much too long to comprehend. These decisions are made much more quickly, so much less time and much less reasoning, so little reasoning that it can be hard to know why the court is doing what it's doing. You only know what they're doing. And that raises real problems for lower courts if they're trying to kind of read the tea leaves. What's going to happen with this other case that's similar to the case that the Supreme Court decided if you don't know why they decided what they decided or how the votes broke down? It's really hard to make those decisions. It's hard for litigants and lower courts to respond.
And just to jump in on and build on something Constance was raising there, is that, we've talked in the past about ways in which the Supreme Court was sort of taking power from not only Congress but also lower courts, and sort of taking that power for itself. And this use of the shadow docket is an example of that, because a few years ago, Justice Alito was giving a speech, and he talked about the shadow docket and that the decisions there aren't what we call precedential. In other words, they don't bind the courts going forward, in part because they're decided on an expedited basis, and also the reasoning is often not entirely clear. Just to put some facts on it, in some of these cases, what we're seeing is district courts issuing 100-plus page orders explaining their reasoning for why they're prohibiting the administration from taking a particular action. And the court will then, the administration will then go to the Supreme Court and say, we'd like you to stay that lower court order. In other words, allow the administration to take the action. And overwhelmingly, more than 80% of the time since this administration has been, this has been happening, they've said, yes, we are going to stay that lower court. We're going to allow you to do what it is you're doing, even if we think, even if there are very good arguments that it's unlawful.
Okay.
But it's only a couple of paragraphs. So you have this 150-page decision from a lower court going in. And this is, we were talking about the trial courts, the district courts, which is where the facts are found and take evidence and so forth. But this is also, I think, fairly said about the courts of appeals, the intermediary courts, where we're also getting very rapid turnarounds, but quite lengthy analyses, either upholding or reversing the lower courts. But on the shadow docket, the opinions are often 2 or 3 paragraphs is all you get. And to loop back to what I was saying about this sort of taking power from the lower courts, sort of a really interesting thing, and I think actually a very unfortunate thing happened earlier when Justices Kavanaugh and Gorsuch both issued sort of a scathing rebuke of a lower court for not abiding by the precedent. This was regarding to one of these funding cases. There have been many of them, but a previous shadow docket determination on this funding question. And just as an outside observer, I was like, when I looked at that decision, I don't know how the court was expected, the lower court, the judge here, who in this case was a long-serving Republican appointee, how he was supposed to understand that his decision was bound by that, especially given, what had been previously said. So that's a way in which this is shifting to. We're starting to see like these ideas where the lower courts are having to react to the shadow docket as if maybe it is precedential.
So the basic translation is the Gorsuch and Kavanaugh slapped around a lower court judge for not being able to interpret their couple of paragraphs as some complex, generalizable precedent.
And in that particular case, one thing that makes it especially interesting is there wasn't even a majority of the court that agreed in the ruling in that case where that decision, that separate writing was issued. It was 4 justices agreed entirely with the administration, 4 justices disagreed, and then Justice Barrett kind of split the baby in the middle and agreed with both of them on one thing.
Okay.
And so even the court didn't agree in that case, and it can be very hard for lower courts to figure out how to navigate that. I think it's one of the issues with the shadow docket is, unlike with the regular merits docket, the merits docket, it's like the ultimate like nerd sport. We spend all this time deciding what's the issue, right? And we have this pinpoint, narrow issue that's never been decided in any case before. And so we make sure that we're all having the same conversation.
And as Craig mentioned, the facts at issue have already been adjudicated and stipulated, if you will, by lower court decisions, although that has been in flux in recent years as well.
I wouldn't go that far.
Okay.
Yeah, so I mean that is.
We like to think that the facts are agreed upon by the time it gets to the Supreme Court. Maybe.
Craig
is sort of shaking his head, so I don't know if we can.
I mean, when I'm going to let Constance finish, and then we can loop back on whether or not the facts have actually been decided or should be.
Yeah.
Yeah. So I mean, it's settled that there should be significant deference to what the lower court has determined as to how the facts play out. Not that they're never can be called into question, but it's hard to do. So with those merits decisions, I mean, really, really narrow opinion
precise
that generates 100 pages of opinion writing explaining all the reasons that that's the case. Whereas with the shadow docket rulings, you may have all of these different justices who agree with the outcome for different reasons without knowing that. You don't know who thinks what, and you don't even know what the fundamental reasoning is for their particular decision.
Okay. So I'm not hearing that the 100 pages is necessarily good, but at least it gives us some sense of the reasoning that was used to arrive at a decision versus when these decisions are so fast and so brief, it's hard to know why they were made the way they were made.
Yeah, they're just, I mean, the decisions from the lower courts, just they lay it out. They're very good at describing both the facts that they found and then why, when you apply the law to those facts, you get the result you do. And like Constance said, with the shadow docket, that's not really what's going on. You're really asking, okay, are we going to let this activity go on pending our full resolution of the matter, or are we going to stop it while we decide the matter? That's really what they're deciding at the shadow docket. On these cases, the shadow docket is also used for other administrative things. All capital cases end up having issues go through the shadow docket as well. And so, but this use of it is a unique historically reflection of what's happening right now, which is that when we were talking about that unprecedented push against the customary use, pushing the boundaries of what's acceptable executive authority under the Constitution, that's resulted in more than 350 lawsuits, which is again, I'm just going to keep saying unprecedented because it just is, but that's a huge number of lawsuits against an administration so early. We're still in the first year, but it's directly proportional and reflective of the breadth of the power that's being asserted for the first time by the administration. And so with all of this stuff happening, the district courts are really, scrambling to respond and hear things and get the facts and then issue these decisions. Oftentimes, they're also operating on extreme time limitations. For example, all the firings cases. So mass firings, there have also been firings of appointed officials who arguably were protected from firing for no reason by the executive based on congressional statutes. And then there was the appropriation of money, that companies going out of business or potentially going out of business because the grants had been shut off, or money. And in some cases, money they'd earned. And, that was one of the few times that the administration lost on one of these emergency stays, was a situation where basically they were refusing to pay out money to nonprofits for foreign aid. That's one of the AIDS Alliance advocacy cases. And they had already they'd already earned the money under the thing, not all of it, but I think a large measure of it. And on that one, the Supreme Court did leave the order in place telling the administration to spend that money. But when the next case came up with that same party, and the question was, okay, Congress appropriated billions of dollars to be distributed through these organizations. In that one, the court said, well, we're going to let the executive hold off on paying those while we decide whether or not it can. And so it really is there is an important thing happening that is different now from any past administration, where so many of these things, so much action, so much authority, I guess I would say, is being asserted and being challenged in so many different ways that the Supreme Court is being asked to weigh in on preliminarily, what do we do while we decide this? Do we let the executive exercise this authority or not? And it's overwhelmingly saying, yes, we're going to let the executive do things, even if there's not much likelihood that they'll win in the end, which is a real difference, too, in again, the way the court's processing these claims that was different from the Biden administration or even Trump 1 and certainly the Obama administration as well.
So can we... Sorry, I'm trying to transition from this. So one of the themes of this conversation, we've heard the word unprecedented often, and a way that I think that is manifesting is in the sheer volume of cases, the pace, the number of complaints, the number of countersuits, all of this. However, it might be instructive for a listener. Can we take a single case and kind of break down how that is testing the limits of separation of powers as we know it? Like birthright citizenship comes to mind because that's something that was thought to be part of the Constitution. 14th Amendment, right?
Yes.
Was thought to be a settled thing, but now maybe not. How do we? Is that a good example to think through?
I think that's a great example. Do you want me to start?
Sure.
And then jump in? Okay, so in 1898, there was this case...
Wong Kim Ark.
Wong Kim Ark, yes. I had it, but, anyways. that held squarely that if you're born in the United States, you are a U.S. citizen, with a couple of really specific exceptions that aren't at issue now. And so what the administration has said is that they're redefining birthrights to say, no, that's not the rule under the 14th Amendment, which is the place where this language is found in the Constitution. And they're saying, no, only if you are born in the United States to citizens or lawful residents. And otherwise, you're not, which is directly the opposite of Wong Kim Ark's holding in 1898. And they're asserting this. So there's been a challenge.
And what is, just for clarity here, what does the 14th Amendment say?
Well, the 14th Amendment says a lot of things.
Okay.
But in this case, the 14th Amendment is where we have all sorts of due process and equal protection rights that require
a lot of stuff.
Require the states to give equal protection of the laws and due process to their citizens. But it also defines citizens.
Yeah, so citizens include those born and subject to the jurisdiction of the United States.
Yes.
So the birthright citizenship case, the challenge to it comes down to the meaning of subject to the jurisdiction of the United States, with the argument being made by the Trump administration that some people, many people born in the United States to parents who are not themselves American citizens are subject to the jurisdiction of that other country and therefore not the United States.
Okay.
Which is not that terminology, but that kind of theory of citizenship you see in other countries. But as Craig explained, it's been settled in American law and also by Congress. So there are statutes interpreting the 14th Amendment that extend birthright citizenship. So the executive order purporting to do away with birthright citizenship presents this conflict with the 14th Amendment as interpreted by the Supreme Court, and also a conflict with the 14th Amendment as interpreted by Congress, right? So there's interbranch conflict in both of those ways.
And remind us what happened. My understanding is the Supreme Court told the administration they can't act on this or something, but they didn't rule on the merits of the reasoning or something like that.
Yeah, so this is an interesting case for a couple of reasons. So what happened was there was a challenge, and I think it is safe to say that legal scholars of all stripes generally believe the administration's argument is wrong.
Okay.
And that for all the reasons Constance explained, like that if you are born in the United States, you are a U.S. citizen under the language of the 14th Amendment. Amanda Frost, who's a professor at the University of Virginia now, I think, just issued a paper. It was really interesting where she went back and analyzed right after the Civil War, right around the time of Wong Kim Ark, there were a huge number of challenges to whether or not people were citizens for purposes of running for office in light of the slaves becoming citizens after the Civil War and so forth. And she looked at all of the challenges and there were hundreds of them over the years, and found that nobody was making any argument that would support the administration's position on this. And and there are other conservative legal scholars who have also looked at that and say that that's not what the history of the text is supposed to be. But that's their position. So it's been challenged. They have lost in the lower courts preliminarily. And of course, the very first way it came up is the court issued, and there were 3 or 4 lawsuits related to this case, related to this executive order in different places. And in one of them, the court issued what's called a nationwide injunction. So it said to the government, you have to treat these babies who are being born as citizens while we straighten this out, in part because you are going to lose. Though you have a very low likelihood of success on the merits, which is one of the factors the court considers in granting an injunction. It also balances the equities and the harms. In this case, the harm to babies who might not be listed as citizens and so therefore might be eligible for removal, while even if the court later determines that the administration's position on birthright citizenship is wrong, and therefore they never should have been removed.
It's
too
hard
late.
to bring those babies back.
Exactly. So for a whole host of reasons, there's a lot of harm there. And the issue that went up, so the administration didn't appeal its loss below immediately on the merits of its 14th Amendment argument, but it did appeal this argument about nationwide injunctions and the court held that, in fact, the lower courts couldn't issue nationwide injunctions. Now, why this is interesting is this is exactly the argument that the Biden administration made and was rejected by the Supreme Court. So the Supreme Court has refused to address this issue previously. And there were a number of high-profile cases there were three in the Biden administration where the Biden administration lost on the stay. So there was a nationwide injunction stopping the executive policy under the Biden administration. They appealed and asked for a stay, just like we're talking about is happening today, and they lost on the stay. So their policy was enjoined, in some cases for years, but they ultimately won on the merits. And so the policy was lawful, but it was just basically barred. What's interesting about the CASA case, which is the birthright citizenship case, is that the court actually weighed in. And this might not seem like a big deal, but it's directly opposite to what happened in the prior administration. Also, for this purposes, it's not, I don't think, like it's easy to imagine another way that those putative citizens can be protected. And in fact, within days of this decision, one of the courts basically approved a class of citizens under federal rules allow
like
you
for
to have
a class action.
Exactly.
Okay.
And they made a class of the babies, and so they basically, which had the same effect as a nationwide injunction. In another case, the court looked at it and said, well, we understand that we can't just issue a nationwide injunction, but the court left us this little window, and this case fits within the window for this reason. And so in the birthright citizenship case, the damage, from that ruling has been stayed because of the actions taken by the lower courts that are still protecting the litigants that allegedly are going to be harmed by this. But that's not going to be true in many other types of cases where, for procedural reasons based on decisions the Supreme Court's made in the past, it is much harder to group people together to protect them from harm while they're pending decision. And I think Constance wants to jump in.
Yeah, so thinking about that issue of the nationwide injunction and the court's ruling in CASA, I think it goes back to the issue we were talking about before with the Supreme Court kind of at odds with lower courts, right? So a nationwide injunction or a universal injunction is an injunction that gives relief to people other than the plaintiffs in the case. Class action is different because there's this procedure that gets followed. It's more expensive. It's more time consuming, but it's also not available in every case. And so a nationwide injunction would just say, no, this thing that you're doing is unconstitutional. You can't do it, right? Because it's unconstitutional, you can't do it. Here, you can't do it
to this one person who complained. You can't do it to anybody else.
You can't do it to anybody else.
Yeah.
It's unconstitutional. And so it prevents all of these other people from having to bring their own lawsuit. And an example of a case where that might have a significant impact would be with the mass firings, for example, where you would have some individualized determination as to each people. It might be hard to get a class action certified, but you could determine that the way that the executive branch has acted kind of universally is unconstitutional. But the court's ruling in CASA puts an end to that.
And so, I mean, part of the reasoning or one of the issues at play here is, should a lower court judge have the authority, should a lower court judge in a state, whatever, have the authority to right policy that affects the whole nation instantaneously?
Right.
That's a question here, right?
Yeah, and it's a question that, as Craig said, the Biden administration asked the court to resolve in its favor. So did the Obama administration.
So the Supreme Court's
did.
treating the Trump administration differently on the same question that it treated the Obama and Biden administrations differently.
Well, I do think that there was a lot of cases where the court just didn't reach the issue of whether or not nationwide injunctions were unconstitutional. One way in which they could do that would be by instead finding that an administration was likely to succeed in the case, or find some other sort of way out of avoiding that issue squarely and closing the door on that tool for lower courts.
Okay.
And the birthright citizenship case really squarely presented that issue because it's a hard case to make legally for the Trump administration.
And is that case being made this year? Like, is this question being called? Okay, so let's focus on that for a moment. So we go through all this debate about national injunctions and whatever, but like now the actual merits of the case are coming to bear. This seems like an important test case of this shifting power dynamics that we've been describing. Is it not?
I'm going to say no.
Okay.
And I think it's because of the reason Constance just said, which is that, most legal scholars look at this and say, this is not a hard question.
Okay, so you're saying the Trump administration is likely to lose, case closed, no big deal?
I never want to, make tea leaves, read tea leaves with the court, but I honestly will be surprised if the administration wins on this. I do think, I do think that with a complete lack, and I have not yet seen the administration make a cogent argument as to why its interpretation of birthright citizenship is justified by the text and the history. And I've seen a lot of very cogent arguments as to why the history and the text go the other direction. I think you can look at the National Guard deployment case, which just came down last month, as an example of where the court was that's another case where they allowed some of the orders to stay in play. Like they initially stopped the lower courts from enjoining the deployments, but then, when the lower court said, well, we're going to stop, we won't allow you to deploy the troops, but we will allow you to federalize them. They sort of let that one stand for a little bit longer, a bit less of an intrusion on the executive's authority maybe. But when they looked at that, they said, well, your argument is based upon an interpretation of the term regular forces, which is what's at issue there, that just doesn't have a support in the record.
I just wanted to add with the birthright citizenship case, and I agree. I think the court might just resolve it on statutory grounds, just look at the laws passed by Congress and not even decide the constitutional issue. One thing that it does raise, though, is we are seeing all of these cases going to the Supreme Court and decided on the shadow docket, but we're generally seeing the administration appeal to the Supreme Court in those cases that it thinks it's going to win on, right? And there are all of these other cases that aren't being appealed on that basis that are out there with courts issuing adverse decisions that the administration is not appealing because it's being strategic in what it brings up. And I just wanted to highlight one thing that came out during the oral argument in the first birthright citizenship argument. So not on the merits, going back to that nationwide injunction thing.
Yeah.
The Solicitor General, so the top Supreme Court advocate in working for the Trump administration, told the Supreme Court that the administration would abide by the Supreme Court's decisions and by the reasoning supporting those decisions, but declined to promise to abide always by decisions issued by other courts. So it leaves this possibility of a gap, right, where courts have issued adverse decisions nationwide injunctions aren't available, and the administration is going to say, okay, we will abide by this decision as to this one plaintiff who brought the case, but we're not going to change our policies overall. We're going to keep doing it, forcing individual people to find a lawyer and to litigate a case in order to get the same relief.
Yeah. So a further assertion of its power.
Right.
Yeah.
Right.
And there's a couple of other ways the administration's approaching that too. I think overall, a question we get, or I get, from new students or people thinking about becoming lawyers is sometimes like, well, does being a lawyer matter anymore? Like, is there a rule of law? And I think the answer is yes, although it's quite under strain. But when you look at this, I think in lots of cases, the administration, when it loses, like it did on the deployments case, it does abide by the ruling, and that's true for some of the lower court rulings as well. But there have been instances where the court, where the administration doesn't abide, or it appears not to have abided by lower court rulings. And I think just an easy example of that is Lindsay Halligan, who was appointed as the U.S. Attorney for the Eastern District of Virginia, but the court found that appointment was improper and she couldn't hold that position, but she's still in the position. And another judge just, I believe yesterday or the day before, issued an order in just a routine criminal case ordering her to explain why she was still in the office despite this order. There was also this thing about whether or not the plane, when Judge Boasberg ordered them not to remove people to Venezuela, and then the plane went, and there was some question about whether or not they did that. So there is some concern, like Constance noted, that they put this marker down that we don't have to obey lower court decisions, and we do see some indications of where that's happened, although it hasn't happened in every case. But I will say the other thing that happens is what I call sort of a legal whack-a-mole, which is the administration loses on one argument and then goes ahead and does the same thing but justifies it with a different argument, requiring another set of plaintiffs to bring another challenge on the same issue, which has the same effect of eroding people's confidence in the legal system as a whole.
Yeah. Flood the zone, as Steve Bannon might say.
Exactly.
Different sort of methodology or different substrate, but
I would just argue a different environment for the same methodology.
Last question. We probably should cover it quickly. If we were to reconvene a year from now, like what are the key things that you're looking at? If you had like a top thing that you wanted to pay attention to, what would it be? Craig, let's start with you.
Oh man, I get the hard one first. So I think I'm gonna say that there's this case, Trump v. Slaughter, involving the removal of an FTC commissioner, and I think the general opinion is that the Slaughter's going to lose that case, and the administration is going to be able to remove people at will from positions that Congress theoretically has protected them from, with the one possible exception being the Fed and Lisa Cook, who they tried to fire, and that case is being argued in two weeks from now, on January 21st. So we'll see. They may treat the Fed differently, but hidden in that case, from the public anyways, is a question about whether or not, even were Slaughter to win, could the court order the executive to rehire her? Because she has been fired, because that was one of those cases where the court stayed the lower court injunction preventing her firing. And that has real ripple effects for how plaintiffs are going to be able to get relief from unlawful action by the government, and what that relief might look like, including like how that does have a real corrosive effect on the constitutional order, because if the end result is just that you can pay out money but reshape the executive in ways that was previously considered to be unlawful, I think that's going to be a really important holding. And I think the other thing I would say is, we have seen, as we discussed earlier with CASA and the nationwide injunction case, there has just been an increasing tendency of the court treating lower court stays on arguably unlawful executive power to be irreparable harm for the government. And the reason this is important is what it means is all of these stays that are happening where the lower courts say, no, you can't do that. And then the Supreme Court says, yes, you can while we're deciding it. What that means is they're putting their thumb on the scale and really changing the way that there's supposed to be a balancing of the equities there. And what we're seeing is that the way the Supreme Court's treating is any limit on the courts, any limit on the executive's exertion of executive power, even if that's arguably unlawful, until the Supreme Court says it's unlawful, that is injury that outweighs everything else. And so, like with the, you see it, I think, most clearly in the trans and non-binary passport case about whether or not, the court found that the administration was harmed when the lower court stayed their change in interpretation. But it was not, but the decision doesn't really lay out, and the administration actually never really laid out why just not having that policy was harm. So that's, I think, a really important thing.
Yeah, we've shifted from asking permission to begging forgiveness.
Yes, exactly. And begging so much forgiveness that there's no way to capture it all.
Yeah, it shifts the whole balance.
It's flooding that's the flooding the zone part that you were talking about.
Right. Constance, what have your eyes on?
Yeah, I think I will be looking away from the court. I think what we've seen from the court so far it is, institutionally it's in a difficult position, and the court. I agree with Craig that the court is generally giving the green light to the administration on many of its core priorities. Not all of them, but many of them. I think the real question is going to be, is there some other actor, thinking specifically of Congress, out there?
We haven't talked much about Congress this conversation.
That is going to be a check on the executive branch.
Yeah.
And there are institutional differences that make Congress much better situated than the court to be a meaningful check. Obviously, things would have to change politically. And so, wondering what happens in the midterms, what happens with public sentiment to motivate people in Congress, what the executive branch does that may kind of shake up the partisan affiliation of Congress people. There's a lot of questions there. And I'm curious to see whether or not we see Congress pass legislation that could more effectively curb some of the executive actions. And where I think we would be most likely to see that would be in the funding arena, really deliberately turning off or on the spigot in a way that shifts the administration's priorities, potentially also in the international arena. And that brings up another actor who could potentially check the executive branch, and that's what we'll see, I think, with other nations, other foreign leaders, and if there's conflict there, that's outside of our constitutional order, but another potential other potential actors that may influence. And then finally, there's the voter. We'll see that in the midterms and what happens with Congress, but also in terms of, as Craig mentioned at the very beginning of the podcast, people speaking out, signaling disagreement, and potentially getting the administration to shift its priorities or to kind of push other actors in order to use whatever their methods of leverage are in order to affect that. So for a constitutional law professor who mostly teaches court cases, it's a little weird to say, I'm not really going to look at the court, but I think that's where the most meaningful action, if there is going to be a significant check on executive power, is probably going to come from outside the judicial system.
And can I add just one, because I think that's an excellent point that Constance was making, and I think when we look historically, I would encourage people to look at what happened with Vietnam and with Watergate, where the congressional and the public reaction, I mean, I'm not going to say the public, but the congressional reaction was very different to Watergate, ultimately, although it took a long time for that to happen. But when it did, it was the combination of the court and the Congress and the public and the press all being focused on this issue that I think led to the outcome that it did at the time. And so I do really think it's all of those things that, you know, no one branch or none of the entities we've talked about by itself can check the executive if the executive wants to exceed the lawful bounds of power.
Well, never a dull moment. I hope this becomes a tradition, this annual check-in. And, you know, maybe we'll have mid-year check-ins as the news cycle demands. Hopefully nothing too crazy, but always great to catch up with the two of you. Thanks for all you do to help listeners understand this dizzying world we're living in and all that you do for our students to prepare the lawyers of the future. Thanks for being here today.
Well, thanks, Justin. We really appreciate you having us on.
Yeah, thank you.
Thanks for listening to A New Angle. If you like what we do and want to support us directly, please consider a subscription at anewanglepodcast.com. A New Angle is recorded at Studio 49, a generous gift from UM alums Michelle and Lauren Hansen. Our presenting sponsor is the Headwaters Foundation, working side by side with Western Montanans to improve the health of our communities. We are also supported by First Security Bank and the University of Montana College of Business, with additional help from CED, Drum Coffee, and Montana Public Radio. Keely Larson is our producer. Libby Riddle is our production assistant. And finally, John Brownell, Jeff Ament, and John Wicks made our music. Thanks a lot, and we'll see you next time.